Tonight, we begin with a development that immigration attorneys had feared, applicants had dismissed, and government insiders had quietly prepared for. A policy change that unfolded not over years of congressional debate, but in a single administrative memo. A single memo that could affect millions of pending applications. A single memo that connects your tax returns directly to your green card eligibility. A single memo that gives USCIS unprecedented access to your IRS records. What the Department of Homeland Security did this month crossed a line that immigration advocates had hoped would hold. And when that line broke, the immigrant community did not hesitate to react. They responded with confusion, with panic, and with urgent questions that deserve answers. Tonight, we're going to break down exactly what this USCIS IRS data sharing agreement means for you, your family, and your American dream. For months now, there had been signals. Not official announcements, not press releases, just whispers. That USCIS was preparing something unprecedented. USCIS has been strict, yes, but they have been predictable in their strictness. Their adjudication patterns have followed a certain logic, a rhythm, almost a formula that experienced attorneys could anticipate. But what set off alarm bells in immigration law offices across America this winter was that the predictability went silent. Attorneys who monitor USCIS processing patterns know the indicators. The sudden increase in requests for evidence related to financial documentation. The unusual delays in employment-based green card cases. The uptick in denials citing discrepancies in financial records. The sudden silence from USCIS Public Affairs. All of that went quiet. And whenever USCIS goes quiet, it means something significant is about to become policy. Immigration insiders began noticing that cases which should have been straightforward approvals were being held. Cases where sponsors had strong income, where applicants had clean records, where everything appeared in order. Something was happening behind the scenes. Something that would connect two of the most powerful databases in the federal government. And that something has now been confirmed. Early this month, Department of Homeland Security officials confirmed what they described as an enhanced verification protocol, including direct real-time access to IRS tax transcripts that had not been implemented in immigration adjudication in over 2 decades. These are the kinds of data sharing agreements that federal agencies only implement when they are signaling something very specific: enhanced enforcement, fraud prevention, or a fundamental shift in how eligibility is determined. Immigration attorneys didn't know which category this fell into, or whether it fell into all 3 at once. But what they did know was that USCIS was changing its verification posture. And when an immigration agency shifts its verification posture without public comment, even by a small administrative measure, every applicant needs to pay attention. Here's what the new system actually does. Previously, USCIS relied primarily on tax returns and W-2 forms that applicants themselves submitted. Officers would review what you provided. Now, USCIS officers have direct electronic access to your complete IRS tax transcript. Every return you've filed, every amendment you've made, every discrepancy between what you reported and what your employer reported. This is not a spot check system. This is comprehensive, automatic, and immediate. The warning issued by immigration attorneys nationwide this week was not routine. It was not standard advice. It was not typical caution. It was urgent. Attorney after attorney, in consultation after consultation, described the USCIS IRS link as unprecedented in scope, retroactive in application, and perhaps most importantly, unforgiving in its precision. You see, many applicants over the years have had minor discrepancies in their tax filings. Perhaps an employer reported slightly different income than what appeared on a pay stub. Perhaps a self-employed applicant estimated their quarterly taxes imperfectly. Perhaps someone filed an amended return that they forgot to mention in their immigration application. In the past, these minor issues rarely surfaced. But data sharing only works if the system catches everything. And this system catches everything. In fact, the level of integration we're seeing is among the most comprehensive we've witnessed in immigration enforcement history. Here's what we know. Within weeks of implementation, USCIS began issuing requests for evidence specifically citing IRS transcript discrepancies. These weren't the typical RFEs asking for additional pay stubs. These were targeted inquiries. Documents that specifically asked applicants to explain why their submitted tax returns didn't match their IRS transcripts to the penny. Tonight, immigration law firms confirmed that USCIS has launched verification checks on pending I-485 applications, including employment-based cases that had previously been considered routine approvals. USCIS cross-referenced records before applicants could even respond to initial evidence requests. They flagged cases with income discrepancies. They flagged cases with unreported cash income. They flagged cases with amended returns that weren't disclosed on immigration forms. In other words, USCIS targeted the documentation foundation of green card eligibility, the financial evidence that proves you won't become a public charge. This is what made the attorney warnings so urgent. The USCIS-IRS connection wasn't just administrative, it was transformational. It represented the kind of verification capability that could result in thousands of denials if applicants aren't prepared. And immigration advocates, understanding that fully, responded with force. Not recklessly, not with panic, but strategically. They didn't tell clients to abandon their applications. They didn't advise people to withdraw pending cases. They advised immediate tax transcript reviews. They advised proactive amended return filings where necessary. They advised complete honesty in responding to any USCIS inquiry. And here's where the story becomes even more critical. Policy analysts now believe that USCIS's data sharing initiative was designed to test the accuracy of self-reported financial information after years of relatively lax verification. USCIS wanted to see whether applicants would self-correct when they knew verification was possible. But instead, something unexpected happened. Applicants didn't panic. Attorneys mobilized with a response that was so coordinated, so rapid, that even USCIS took notice. You don't get the federal government's attention easily, but this month, the immigration law community did. Immigration policy experts speaking with legal publications under anonymity described USCIS's initiative as aggressive verification, a way to reduce approval rates without changing statutory eligibility requirements. But attorneys proved this month that they remain both vigilant and prepared. Their client advisories were not only timely, they were detailed so precisely that applicants knew exactly which documents to request from the IRS before USCIS did. That preparation matters because it shows something important. It shows that the immigrant community is not passive. They are proactive. They are informed. They are ready. As reports continued coming in throughout the week, we learned more about the scale of USCIS's verification expansion. Employment-based applicants saw RFE rates increase by an estimated 40% in categories requiring income verification. Family-based sponsors with self-employment income reported unprecedented scrutiny of their I-864 affidavit of support filings. Adjustment of status applicants with any history of amended tax returns found their cases flagged for additional review. This wasn't just enhanced verification. This wasn't just fraud prevention. This was systematic financial scrutiny. This was comprehensive data integration. And comprehensive data integration is the one thing that applicants with minor tax discrepancies have struggled to navigate since the program began. For every case that moves forward cleanly, another is now being delayed for explanations that would never have been requested before. Remember, Many applicants thought tax discrepancies from years ago wouldn't matter. They thought amended returns filed and accepted by the IRS would never surface in immigration proceedings. They thought minor income reporting differences would be overlooked. But tonight, the exact opposite is happening. Old tax issues are being discovered through automated cross-referencing. Amended returns are being flagged as potential evidence of inconsistent testimony. Income discrepancies of even a few $100s are generating formal requests for evidence. The past, for immigration purposes, is no longer past. It's present, it's accessible, and it's being used. What makes this moment so significant, and so consequential, is that the USCIS IRS data link happened at a time when the immigration system is under enormous political pressure. Restrictionist advocates want reduced legal immigration approvals. Enforcement advocates want enhanced fraud detection. Congressional oversight committees want accountability metrics. And the administration wants demonstrable immigration enforcement results. USCIS leadership is balancing these demands while facing massive case backlogs and processing delays. And when agencies in that position implement sudden verification expansions, they're not doing it from bureaucratic routine. They're doing it from pressure. They're doing it from political necessity. They're doing it because someone, somewhere, demanded results. USCIS's official statement, now circulating among immigration attorneys, was designed to signal that the agency is not willing to approve cases with unverified financial information. Officials said plainly that applicants' submitted documentation must be consistent with federal tax records. That is bureaucratic language for, we're checking everything, and it better match. You don't usually hear that level of verification emphasis from USCIS unless something serious has changed at the policy level. And something serious has changed. Meanwhile, prominent immigration attorneys addressed their clients and followers in urgent, direct communications this week. They said, request your IRS tax transcripts immediately using Form 4506T. They said, compare every line item with what you submitted to USCIS. They said, if there are discrepancies, consult with a tax professional and an immigration attorney before USCIS contacts you. These are not theoretical suggestions. These are action items from professionals who understand just how high the stakes have become. Here's what makes the situation even more concerning. The USCIS IRS link wasn't isolated. Along with tax data integration, Social Security Administration data is now being cross-referenced for employment verification. State unemployment records are being accessed to verify work history. Department of Labor wage data is being compared against sponsor income claims. All of this happened within the same policy update period. When USCIS connects multiple databases at once, it means something larger is underway. A comprehensive verification infrastructure is being built, and once built, it will be permanent. Analysts are now considering several possibilities. One is that USCIS is preparing to significantly increase denial rates for financially marginal cases. Another is that USCIS is attempting to reduce backlog by finding disqualifying evidence more efficiently. A third possibility, the one worrying attorneys the most, is that USCIS is building a permanent verification system that will affect every future applicant indefinitely. But today, prepared applicants can take that uncertainty off the table. They don't have to wait for an RFE. They don't have to guess what USCIS knows. They don't have to hope discrepancies go unnoticed. They can verify their own records first. They can correct issues proactively. They can respond to USCIS with complete, accurate documentation. What we're watching now is a test of preparation. USCIS wants to see which applicants have accurate, consistent financial records. Applicants need to show that their tax history supports their eligibility claims. Immigration attorneys want to prevent denials through proactive case review. And advocacy organizations want to prevent this system from becoming a tool for arbitrary denials. Tonight, we've heard from immigration law firms who are now monitoring RFE patterns closely. They say request for evidence rates have increased significantly for cases involving self-employment income. They say cases with any amended tax returns are receiving heightened scrutiny. And they say USCIS's decision to implement real-time IRS access is likely part of a broader verification strategy intended to reduce approval rates through documentation failures. But applicants are not powerless. In fact, applicants are responding with unprecedented preparation. Their response, informed, proactive, and strategic, sent a message to USCIS that immigrants are ready to meet verification standards. And it sent a message to attorneys that early intervention saves cases. As the weeks go on, we expect more details to emerge about exactly how USCIS is using IRS data in adjudications. But what we do know is that the attorney community's early warning was timely. It gave applicants time to review their records. It gave families time to consult with tax professionals. And it gave everyone time to prepare before USCIS acts on discrepancies. What happens next will depend on what applicants do in the next 30 to 60 days. If they review and correct their records now, this moment will be remembered as a warning that saved their cases. If they wait, USCIS has already shown they are ready to issue RFEs and denials. They have shown they are ready to verify. They have shown they are ready to act. And tonight, for the first time in decades, USCIS has access that changes everything. The data is there, completely accessible. And when USCIS has access, it means they are using it. It means they are checking every case systematically. Because tonight, every applicant learned something critical. Your tax returns are no longer just tax documents. Your tax returns are immigration evidence. And your tax returns must match exactly what USCIS can now verify independently. This story is far from over. But tonight, one thing is clear. The USCIS-IRS connection is real. The verification is happening. And preparation is no longer optional. It's essential. And we will be here, watching every detail, as this policy continues to unfold.